So in July last year, this House passed the ACRA Registry and Regulatory Enhancements Bill. Amongst other things, the bill introduced a framework that sought to protect the confidentiality of personal information by limiting public access and allowing only specific parties access for the purposes of fulfilling regulatory obligations. Minister Indrani, in moving the bill, confirmed that the bill laid the groundwork for the enhanced BizFile system that was targeted for launch at the end of 2024. No mention was made in the minister's second reading speeches about the government's new approach vis-à-vis NRIC numbers. A public consultation was also undertaken for the bill in March which was published in March 2024. In this consultation, ACRA had proposed, and I quote, to partially mask the identification numbers of all individuals in ACRA's registers which are made available to the public and introduce a contact address that will be shown to the public, unquote. There was some feedback to this proposal, principally related to corporate transparency and know your client requirements. ACRA responded to this and said, I quote, on the proposal to mask identification numbers, the concerns on requiring access to full identification numbers have been duly noted. We will review this further and provide an update in due course, unquote. So my first question, as the issue of the masking of NRIC numbers was clearly in ACRA's contemplation for the purposes of the amendment bill in July 2024, when did ACRA intend to provide an update to its public consultation? And in view of the reply, if I heard correctly from the minister, the circular came into being in July 2024. When was ACRA intending to provide an update to its public consultation? And why did it go ahead, especially in view of these public representations? Secondly, ACRA and the government would have been acutely aware that the public treats NRIC numbers as personal data and for personal data privacy reasons, and that these should not be disclosed to the public. I think Minister acknowledged that in her Minister Josephine Teo acknowledged that. But in 2022, on the back of amendments to various corporate statutes, the point was acknowledged in Annex A of a public consultation exercise for another bill that NRIC numbers are confidential information. My second question, therefore, is in view of the serious and significant public concern about how unmasking NRIC numbers could have occurred so easily, despite enough feedback about not just how the public, but ACRA itself views the sanctity of NRIC numbers by virtue of its consultation exercises in 2022 and 2024, surely the matter would have had to be brought to Parliament instead of simply interpreting a circular from the ministry. That's the second query to the minister. And finally, I note my question 25 in yesterday's order paper. Subsections B to D of that question really have not been answered. So I would appreciate a reply from the minister. Thank you.
If the Leader of the Opposition, just give me a moment to check the notes on this. Okay. Just a few things. I don't have all the details of what the LO has asked, but what I can give him is some of the details. First, the summary of the public consultation was issued in April of 2024, and in the summary of the consultation, what was said was this. I think under the proposal, right, to partially mask the identification number of all individuals in ACRA's registers, which were made available to the public, and introduce a contact address as the default address of individuals that will be shown to the public instead of the individual's residential address. So feedback, some respondents expressed concerns on the need to have access to full identification numbers and other personal data for corporate transparency and compliance with Know Your Client's requirements. Some respondents sought clarification on whether there would be still sufficient information to identify an office holder that is tied to a particular business entity on ACRA's registers. So the first piece of feedback that you can see is that there are two types. Some expressed concern about, having full identification numbers made available. Others needed to know how to identify the right person. ACRA's response was to proceed with the proposal to introduce a contact address as the default address of individuals that will be shown to the public. On the proposal to mask identification numbers. The concerns on requiring access to full identification numbers have been duly noted. We will review this further and provide an update in due course. I think that's what the LO was referring to. So my understanding, and this is going to have to be dealt with more deeply in the review because they'll be looking into the matter. But my understanding was when ACRA was looking at this, they were deciding whether or not to even give full NRIC numbers. But on the MDDI side of the House, they had been indicating that they were reviewing this. And so that was put on hold. Then after that, the July circular came along and the misunderstanding occurred, and then that's what happened. So that is the short sequence of what I know, but the review panel will look into this in more detail.
To ask the Minister of Digital Development and Information, when was the ministry's circular that sought to change the practice of masking NRIC numbers dated and communicated to government agencies? I think the Minister answered by saying July 2024. Part B was, when did the ministry determine that such a change was necessary and began planning for it? C, whether any whole-of-government discussions took place before and after the issuance of the circular. And D, how many other agencies apart from ACRA misread or misunderstood the circular?
Mr. Speaker, in response to the member's question, for the circular minute to have been issued in July, I don't have the exact date when the discussion started. It would have to be months before that this was already discussed. To his question were whether there were whole-of-government discussions, as would be typical of a change of this nature. Besides issuing circulars, there would also have been briefings, and the briefings would have allowed for clarifications. Then upon those clarifications, it would also be quite a common practice amongst government agencies to compile frequently asked questions in order to provide useful references to colleagues. So I can share with the member that these things did take place. Now, as to how exactly the incidents unfolded, I seek the member's understanding and members' kind support. At this juncture, if we were to start pointing to this particular event, that particular occasion, it would still not allow us to piece together the whole picture. And if such episodic events were discussed, you could invite further questions. And I think what could be even more difficult is if we gave the impression that there was an effort to conceal certain parts of the process because we were only talking about parts of it. So I think I would refrain from further citing specific events leading to the incident of 9th December, the launch of the new BISPAL and the other associated events around it. So I seek the members' understanding that it would not be a very good idea for us to keep going into the specific details.
The first is that I understand that there are about 500,000 queries, but given that we do not know actually whose NRIC was being accessed, would the government consider issuing individual notifications to the different households on in the four major languages just to inform them of this incident and the necessary precautions that need to be taken just to ensure that people are prepared? And I say this also because in the case of private organizations, then should there be a data breach, they are actually obligated to inform both the PDPC and the individuals affected. Second is it's actually part of my original PQ in that what is the government's assessment of the risk of NRIC numbers being potentially used to unlock large amounts of personal information. And I think there was a Straits Times article that talked about how it can be used to access bank information, healthcare records. And in so doing, has the government actually given a timeline for both the public healthcare institutions or private financial institutions to stop the use of the NRIC as an authenticator? Thank you.
Mr. Speaker, I thank the member for his question. I think following the media conference as well as statements that were made in relation to the BizFile incident, I recall that the Association of Banks have issued a statement on how they do not allow, or banks do not have the practice of using the NRIC number as a sole factor of authenticator. I think the awareness in certain sectors is certainly reasonably high. I believe the telecommunications companies may also have issued a statement. It was in the festive period, so I apologize if I cannot remember specifically who issued what statement. So within the sectors where there are regulators, I think we can say with a good degree of confidence that the awareness about the inappropriateness of using NRIC numbers as a factor of authentication is quite high. But again, we do not want to assume. We still want to go through the rigor of ensuring that such practices stop. I would say that outside of these regulated sectors, there are a very large number of companies. And it would best be for us not to assume that the incorrect uses of NRIC numbers is well understood. So our working assumption is that outside of the regulated sectors, we have an even bigger challenge. Having said that, I want to go back to the answer that I provided in response to Ms. Haniso's questions. If you look at the NRIC-related scams that we've observed thus far, most of it relates to the victim thinking that they were dealing with a figure of authority because that person, the scammer, was able to cite the NRIC number. Police have actually not been able to specifically identify cases of NRIC-related scams where the NRIC number was inputted to steal valuables. That it has not so far been the commonplace observation amongst NRIC-related scams.
Mr. Louis Chua sought a clarification on whether it would then be a good idea to give notices to all individual households, informing them about the incident and letting them know what to do. The first thing to clarify is that the NRIC numbers in ACRA are not the NRIC numbers of all Singaporeans. So actually sending them to all households would actually sort of be beyond necessarily the number of NRIC numbers that were with ACRA. The other thing to bear in mind is that those who have incorporated a business or have taken on board, directorships, etc., and have their information with ACRA would know that their information can be made publicly available. So I think the better approach is really this. For everybody who has provided information in lodgements or filings in ACRA to take heed of what we have indicated, which is first, don't use your NRIC as a password or authenticator. Two, be careful if somebody comes citing your NRIC, asking you to do something. And this would be part and parcel of the public education that we would put out. But it's not necessary, I think, to sort of notify all households.
Thank you, Speaker. I have clarification for Minister Josephine Teo and one for Minister Indrani. Minister Teo earlier talked about the use of NRIC numbers or information as authentication, and she drew the distinction between the use of the number itself versus, say, the production of the NRIC card, which you said could be used for authentication because it contains more information. I'd like her view on how this would apply to the digital NRIC that is in our SingPass, because most people don't carry the physical card around anymore. And I mean, I found from personal experience that going to the bank, they still want me to produce the physical card. So I'd like her opinion on whether she thinks this distinction between the physical card and the digital IC in SingPass is a logical and well-founded distinction. So should actually the digital IC be taken as acceptable for authentication purposes? I'd like her view on that. For Minister Indrani, earlier she touched on this MDDI circular minute that we all here has been misunderstood by ACRA. And she mentioned that ACRA actually sought a clarification from MDDI. What was the nature of the clarification, and was there any reply from MDDI to ACRA's clarification? And related to that, there is intense interest in the public on the circular. So I'm just wondering whether she would agree that for the review panel, at least, when they put up their report, that this minute could be made public so that people can form their own judgment on how this misunderstanding could have occurred.
Ms. Lim asked a very relevant question. Does the digital NRIC card suffice as an authenticator? If you open up your SingPass app and you tap on your digital NRIC card, you will see your photograph, and therefore containing this information allows the digital ID card to be matched against the person holding the device that shows this digital NRIC. In fact, we have said quite clearly that the production of this digital NRIC card, digital NRIC, is the same as producing the physical NRIC card. So I think that part is quite clear. And I think, so it would be acceptable as an authenticator, if I could just put it across that way.
I thank Ms. Lim for her question, and I can understand the curiosity. First, I think let me deal with the issue of when ACRA sought clarification whether there was a response. There was a response, and I understand that the communications continued for a while. The reason why I'm not saying more about this is so that the review panel can look at it in detail, because as Ms. Lim would appreciate, and I think indeed almost anybody who's done an investigation, people when they communicate with each other, whether it be verbally or in writing, don't do it in nice, complete sentences that flow on nicely. There will be short phrases. There will be you sort of you make a guess at what the other, or you assume what somebody else is saying. You use a short phrase, right? So all of that has to be pieced together in a review, the full picture put together, and then you get an understanding of what happens. So suffice to say, as I have summarized in my ministerial statement, they did talk. It's not that they didn't talk, because ACRA did have some concerns. But what is very clear is that there was not a clear understanding of the policy intent, and in some cases it really was a lapse of coordination. And that's as much as I can say at this point. On the second point of whether the document, the minutes, should be released or not, that I will let the panel decide. But the general principle is for government documents, you normally don't release the government documents. What does happen sometimes is the relevant extract or the relevant portion does get cited. And at least for these purposes, in my statement, the most material part is what I have said was in the minute, which was the words to cease the use of the partial masked NRIC. So that is really the most relevant part of that document, and that is what led to the incident in question.
Thank you, Mr. Speaker. I just want to clarify with Minister Indrani, and this relates to my question 36. In respect of persons whose NRIC number has been downloaded and then subsequently, has been accessed, and if subsequently it's been proven that it's been accessed and downloaded by malicious actors for scams or onward sale during the period of 9 to 13 December, is the government prepared to provide suitable compensation or remedy to such individuals? Thank you.
In response to Mr. Tan's question, I think the first difficulty here that we have, which is what I indicated earlier, was that we don't know what information might have been accessed or whose information. So, in the first place, to talk about compensation assumes that you know whose, and somebody could come and say, "Oh, my information has been accessed, therefore, I should be compensated." But that leads to the second and the more important point: anybody who has filed or provided personal information in a document or lodgement with ACRA would know that that information is available publicly. So, for example, if you're a director and you file a document saying that you're a director, you would know that that information should be made public. Because as a lawyer, Mr. Tam would know that Mr. Tam would have done public searches, right? ACRA searches. When you're going to commence a suit and you're looking to see which director to sue, you would do an ACRA search and you would look for his NRIC number and you would actually put his NRIC number on your writ of summons when you issue the thing against him. So if the claim is that the NRIC number was made public, then the suggestion is that it is wrong to make it public. But information in ACRA is actually permitted to be made public. That is the nature of a registry. The nature of a registry is to be a register. And the nature of a register is to have information. And the nature of that information, the register, is put there for a purpose, and that purpose is for the public to access it. So there would be some issue there, I think. So in that sense, so the short answer to the question is, at the moment you don't even know who. But second, insofar as the suggestion is that it cannot be made public, the answer is that such information can be publicly accessible. So I'm not sure the context in which a question of compensation arises.
First of all, Minister Teo, how long has the government known that organizations, including those in the public sector, have been using NRIC numbers as an authentication factor? And why did it not prohibit its use long before December 2024? Up to December, large regulated organizations like insurers were reportedly still using NRIC numbers as default passwords. I know the Minister said earlier that the organizations should stop doing so as soon as possible. Will the government legally prohibit government agencies and organizations from using NRIC numbers as authenticators and do so by a certain deadline? Secondly, I note that Minister Teo replied to me earlier that the risks do not arise directly from the structure of the NRIC number. However, my question about this alternative NRIC structure arises because a masked NRIC can still be reverse engineered due to the algorithm and checksum that it follows. While this algorithm is not officially published, it is widely known. So my question is, what prevents the NRIC from being randomly generated moving forward instead of relying on an algorithm? If the concern is that businesses need to check the validity of an NRIC number provided, I would highlight that many NRIC generators online can already produce numbers that pass this checksum. And to Minister Indrani, business owners and corporate secretaries have reported that many share transfers and annual returns could not be submitted on the new BizFile portal after it was launched. And these are basic functions that every business owner uses. Was sufficient user acceptance testing conducted and signed off by ACRA before the launch of the new portal?
Mr. Speaker, I thank Mr. Giam for his questions. As I said in my ministerial statement, the problem is relatively contained. So whilst we have observed instances of, for example, bank statements being sent to individuals and being accessed with, most of the time, partial. Usually what people receive is you need a password to access a file that is attached to an email. Although the email is already encrypted, for whatever reasons, these organizations still believe that it is necessary to attach another layer of access security for the document that is carried as part of the email. So this process then involves very often using a combination of some other identifier, some other information, could be date of birth, combined with part of the NRIC number to access. The question has to be, is there really a need for authentication to begin with? If you use the example that I just raised, previously, before statements of this nature were sent via encrypted mail, it would have been mailed to our homes in a little envelope. And that envelope does not need a special password to open up. So the fact that some organizations have decided that they need a further layer of authentication in order to access that bank statement, firstly, we would invite the organization to think through, do you really, really need it, right? So that's one question. If they still choose, for whatever services that they make available digitally to their clients or to their stakeholders, they would require authentication, then I'll advise to them that the NRIC number is not a very good authenticator. You should not use it at all. So I think that remains. As to the question of whether we will legally prohibit the use of NRIC numbers as authenticators, as I said, the practices for the private sector will have to be decided upon consultation. So I do not want to say what the landing point is going to be, but even without a legal prohibition, I think organizations, if they care about their data security and they care about protecting the data that they have in their possession or the services being accessed by people who are not intended to enjoy the service, then they should really rethink the authentication methods. Their customers ought to be sensitized to this too, that when the NRIC number is being used by your organization as an authenticator, it's actually not safe at all. Now, it goes to your point that there are algorithms online that will allow you to work backwards, using the mask numbers to uncover the full number, which is why we are advising our own public agencies to move away from the use of the mask numbers and not to give themselves that false sense of security. I think your question has to do with the fact that how about if you invented a new identifier that cannot be worked backwards? That cannot be worked backwards from the partial identifier. I think my answer still stands. Whether you can work out or you cannot work out, the identifier is not meant to be a secret. It is not shared widely, but some people will know. The persons whom you revealed it to, for example, at the clinic, the person that you revealed it to when making a mobile line application, even if we reach a stage where we do not reveal the partial number, we reveal the full number, if this person was determined to get hold of your identifier, the NRIC number in this case, or any other identifier that you use to access information and services that are not meant for them, they will do so. It comes back to the fundamental point. Even if you cannot work out the full identifier from a partial identifier, as long as that identifier is used for the purposes of authentication or as password, you still have a problem. I hope that explains our position and our thinking.
Minister Indrani.
Mr. Gerald Giam had a clarification on difficulties encountered by users with respect to share transfer forms and the annual returns on the new BizFile portal. Can I just confirm with Mr. Giam that that has nothing to do with the NRIC issue? That's a separate topic, right? Okay. On that, I think that as a new BizFile portal, I understand that there have been some initial issues with the portal. However, what ACRA has done is that they have informed, they have given an extension of time to users who need to file the documents, and they have also indicated that no late penalties will be imposed on people who have difficulties with filing. So firstly, extension given, no penalty. And third, if anyone is having a difficulty with their filing still, please do contact ACRA and their service personnel will assist. The contact information is on the website. Sorry? I don't have details on what kind of testing exactly that was done, but what I think I can say with relative confidence is that some testing was done. The question on this specific one, I don't have the answer to that. But anyway, anybody who is experiencing difficulty, please contact ACRA. They will assist you. And in the meantime, they're working to resolve any technical difficulties.
So, very brief preamble for context. I think it's useful to reiterate the distinction, as acknowledged by Minister Teo, between an individual acknowledging that the NRIC number is neither a foolproof nor secure method for personal identification, and hence may be desensitized, and the same individual consenting and being comfortable with their NRIC being released or broadly disseminated. So I think most Singaporeans will agree with the former, but strongly disagree with the latter. And my questions have to do with the implications of this distinction. For Minister Teo, going forward, would the government's policy of desensitizing the NRIC also lead to difficulties in the practical implementation of low-grade access restrictions, such as passwords for PDF documents, like she mentioned early on, that contain confidential but not secret information? And relatedly, if there have been any studies, feasibility studies on what a widespread desensitized NRIC policy could mean for the day-to-day operation of businesses in our economy. And for Minister Indrani, if indeed it was within the government's rights to release personal information on company directors according to the ACRA Act, could this then deter individuals from being willing to take up directorships, especially for small and micro businesses where friends and family are often roped in as directors? And if so, whether some kind of opt-out clause for deep personal information, including address and NRIC, beyond just the name, for directors for such small firms would be possible, because at least for smaller firms, these kind of deep due diligence may not be necessary.
Mr. Speaker, two quick responses to Dr. James Lim. First, I believe that his opening sentence in his preamble is erroneous. We did not say that the NRIC number is not suitable for identification. It is an identifier. It is a unique identifier. So it has to be used for identification. It is authentication that it should not be used for. You can use it to identify a person. You cannot use the NRIC number to prove that the person is who he claims to be. So I would encourage Dr. Lim. I do appreciate that there's a lot to take on board. So I would refer him to the specific statements on this topic, drawing a distinction between the NRIC number as an identifier and as an authenticator, so that we could have a proper understanding of what it is. The second response to his comments is that I'm not sure that it's useful to characterize what we are doing as desensitizing. As I explained, we are not making a change to allow the full NRIC number to be widely disclosed. The only change that we are making is to stop the incorrect uses of NRIC numbers as authenticators and as passwords. Nowhere in this description is there a need to refer to desensitization. I'm not sure that that characterization applies to what we are seeking to do, and I would encourage members not to use this characterization. To reiterate, we are not making a change to allow full NRIC numbers to become widely disclosed. The only change we are making is to stop incorrect uses of NRIC numbers as authenticators and as passwords.
Associate Professor James Lim asked whether, the ability to make known NRIC numbers might deter individuals from taking up directorships, and whether there can be some kind of opt-out clause. I think it is necessary to go back to first principles and really the very basics of corporate governance. The reason why you have information available is for corporate transparency. And why do you have corporate transparency? It is to protect the public. You must protect the public because anybody who sets up a business and transacts with the public interfaces with a member of the public. And that member of the public transacting with you may run into difficulties or issues and must then know who they are dealing with. So let's say let's take an example that people can relate to. Let's say your home renovation. Most times, it could be a company, or let's say it's a sole proprietorship. It's Mr. Wong trading as, general renovations. And the name card will say general renovations. You have no idea who general renovations company is. You will go to ACRA, you will search general renovations, and you will find that it is Mr. Wong trading as general renovations. But there could be many other Mr. Wongs as well. So you need to know which Mr. Wong, because if your renovations wasn't done properly and you need to claim a refund, or you need to sue him, for example, you need to know who you're dealing with. So it is the essence of a business register or corporate register that you must know and be able to identify the specific individual or entity that you are dealing with. Hence, it's actually looking at it through the lens in a different way. So if anybody has a concern that they do not wish to have their NRIC known, and for that reason don't become a corporate director, I think that perhaps may be a step too far. But anyway, the bottom line is, in our regime, as well as in many other countries, if you're going to do business that transacts with the public has to know who you are and to be able to contact you. To the extent that we can make some concessions, we have done so. So, for example, for residential address, for example, under the last round of amendments, you can now put a separate contact address. So if somebody needed to sue you, they could leave the writ of summons at your office. They don't necessarily have to go to your residence. So we've made some shifts. But I think on identification, there's no running away from the fact that you still need to be able to identify the individual you're dealing with.